Those words, I now request you to please present a token of our appreciation to Honorable Justice Suryakant. As India marks 75 years of the adoption of its constitution, we present to you a copy of the original constitution, sir. Let's have a huge round of applause. Along with this, we take great pleasure in presenting to you, Justice Suryakant, a photograph of the first session of the Constituent Assembly held on the 9th of December 1946. Justice Suryakant will be addressing our esteemed gathering on a plethora of topics, including the Specific Relief Act and the law, media, and social media. With that, ladies and gentlemen, I request Justice Suryakant to the dais to address the third Law and Constitution dialogue.
Thank you very much. Good afternoon to all the distinguished guests here. Instead of any formal address to a galaxy of personalities whom I know personally and with whom I am associated for a long time, with your kind permission, may I just start with the subject of today's interaction with you. I propose to speak on the 2018 Amendment Act in the Specific Relief Act with reference to, because I was asked to that, keeping in view the economic dimensions and the India marching ahead as a very strong economy in the global map, what are the consequences, what are the effects and impact of the 2018 amendment in the Specific Relief Act? I just thought that I will share my ideas on that. The 2018 amendment to the Specific Relief Act and its potential implications for India's future, both domestically and internationally, is the subject of discussion. India's evolving global positioning becomes particularly pertinent in this background, as it closely aligns with the modifications introduced by the amendment and the overarching object it aims to fulfill. When we speak of disputes arising from the breach of contracts with reference to the original Specific Relief Act of 1963, the granting of remedies to aggrieved parties is rooted in the old principle of ubi ius ibi remedium, which means that where there is a right, there is a remedy. The remedy of specific relief is treated differently across jurisdictions. For instance, civil law jurisdictions most commonly treat specific relief on the same level as a remedy for compensation or damages, whereas this is not so in common law countries. India, being a common law country, has treated the remedy of specific relief for several decades as one steeped in the principle of equity, but paradoxically subject to judicial discretion. In this regard, the legal framework governing the remedy of specific relief in India was encapsulated in the Specific Relief Act of 1963. The objective of this particular statute is to essentially safeguard civil rights and provide remedies for people whose contractual rights have been infringed. The remedies traceable under the Act include a recovery of possession of property, rectification of instruments, specific performance of contracts, rescission and injunctions, among several others. However, despite its wide import, this legislation was often perceived as rigid, primarily due to the imposition of the inadequacy test, which in turn is founded upon the notion of reversed onus of proof. Under this test, An aggrieved party seeking the remedy of specific performance was required to demonstrate that damages under the common law was either unascertainable or an inadequate relief. This test applied to suits for specific performance of contracts as well as to injunctions sought for enforcing contractual obligations. Consequently, specific performance was treated as an exceptional remedy, granting only when court was satisfied that the alternative recourses were wholly deficient and its decree would be effectively enforced. When Section 10 of the 1963 Act codified the inadequacy test, Section 14 and 20 of that Act enumerated exceptions to the grant of specific performance, such as the availability of monetary compensation or the impracticality of enforcing contracts involving minute details. With courts predominantly favoring the award of damages in cases of breach and specific performance being invoked only as an exceptional remedy, the efficacy of the 1963 Act was significantly undermined. The lack of mandate for specific performance of a contract, irrespective of mitigating circumstances exhibited by the losing party, substantially affected the sanctity of contractual obligations. I believe that it is not uncommon for parties to breach their contractual obligations, as the damages awarded often prove to be less burdensome than the cost of performance. Promisors frequently resort to breach when the gains from such breach outweigh the damages assessed by the court. This phenomenon aligns with the efficient breach theory in law and economics, which posits that voluntary breach of contract accompanied by the payment of damages can be economically justified. Proponents of this theory contend that in certain instances it is economically efficient for contracts to be breached. By limiting remedies to monetary damages, the legal framework arguably incentivizes parties to breach contracts when the cost of performance exceeds its perceived value. This, to my mind, eventually derailed the aim of the statute to provide relief to parties and functioned almost as a sort of ancillary legislation with not much application. In this legal framework of the 1963 Act, then came a 2016 expert committee's recommendations. That being the state of affairs, over time it became evident that the existing framework under the Specific Relief Act 1963 was increasingly unfeasible, and an expert committee was therefore constituted to undertake its review. This decision was necessitated by the substantial developments that had occurred since the 1963 when the Act was enacted, particularly in the context of contemporary scenarios involving contract-based infrastructure development, public-private partnerships, and other public projects requiring abundant investments and enforceability of contracts. The review was also aimed at aligning the Act with the objective of ensuring the ease of doing business. Notably, the Specific Relief Act had not undergone any amendment since its inception. The expert committee, therefore, in its report, underscored that the Specific Relief Act in its existing form was inadequate to address the demands of India's rapid economic growth and industrial expansion. It emphasized the need for extensive reforms to facilitate the enforcement of contracts and ensure timely dispute resolution, both of which are crucial to the creation of a business-friendly environment. More specifically, the committee highlighted the limitations of the inadequacy test, which restricted the remedy of specific performance to a narrow set of circumstances. It observed that in many cases, plaintiffs were unable to fully substantiate the losses incurred due to a breach, nor were the claimed amounts consistently awarded. While damages might compensate the injured party, they fall short of fulfilling the contractual obligation that the remedy of specific performance is designed to achieve, often resulting in delays and additional costs. If I were to express this analogy in my own words, denying specific performance in favor of awarding damages is something like refusing indoor admission to a patient, to a critically rather ill patient, and opting instead to administer him just the basic first aid. While the latter may provide some relief, it often falls short of addressing the underlying issue comprehensively, leaving the affected party inadequately remedied. Let us also see when the 2016 committee was constituted and it's decided to make certain sweeping recommendations for amendment in the 1963 Act. Let us see what were the position in law in various other jurisdictions. When we peek over the fence and look beyond our own legal system, the remedy of specific performance varies significantly across jurisdictions, reflecting diverse approaches to contract enforcement. Under common law systems, specific performance is directed against the defendant personally, where the court requires the defendant to fulfill their contractual obligations or face the consequences, such as being held in contempt. In contrast, civil law systems take a broader view. The remedy focuses on achieving the promised result for the promisee rather than merely directing the debtor to act. This approach allows the promisee to have defects cured or substitutes obtained at the promiser's expense. In common law nations, and that I will refer to even United States of America, specific performance may be ordered if explicitly provided for within the agreement. However, the limitations remain the same, namely, specific performance is generally resorted to only when legal monetary damages are inadequate or an incomplete remedy for breach. Similar is the situation in United Kingdom, where broad discretionary powers are granted to the courts. Even in civil law jurisdictions, though the applicability of specific performance is propagated, nonetheless, actual performance of a contract is ordered only in exceptional cases. In countries like France and Germany, the laws are quite wide and they allow substituted performance instead of actual performance, subject to the imposition of restrictions. For example, German law grants specific performance as a matter of right, but with limitations tied to the adequacy of compensation. Enforced performance is typically ordered only when monetary compensation is inadequate. This includes situations where a profit-earning asset is damaged and the loss of profits during the repair period cannot be adequately compensated. However, under the German law, if specific performance results, it's quite interesting provision. If specific performance results in the promisee receiving a benefit greater than what was originally agreed upon, specific performance can be denied. Instead, the promisee would be entitled to compensation equivalent to the value agreed upon by the parties at the time of entering into the contract. A common limitation across most of the jurisdictions pertains to personal contracts, particularly those requiring the promiser's personal services. Courts generally, and in my opinion rightly so, refrain from enforcing such promises in light of potential infringement and violation of personal freedom and liberty. Additionally, courts are often reluctant to oversee or evaluate the quality of personal service, which could involve significant judicial supervision. Lastly, all legal systems recognize the impossibility of enforcing specific performance where it is not feasible for the promiser or any third party to fulfill the promise. This principle underscores the practical limitations of the remedy across jurisdictions. Now, reverting back to the recommendations of the 2016 expert committee and the deficiencies pointed out in the Specific Relief Act of 1963, along with the transformation of the economic landscape, the 2018 amendment, to which I am now straight coming, the 2018 amendment came into force. This amendment indeed marked a significant shift, making specific performance available as a matter of right rather than an exception. This amendment is a testament to the measure that India has effectuated in comparison to other contemporary jurisdictions to create a more streamlined framework which fosters predictability and certainty in commercial contracts. One of the most crucial changes brought about by the 2018 amendment, in my considered opinion, it relates to the onus on the plaintiff to prove readiness and willingness to perform their contractual obligations. Under the old framework, the plaintiff was required to make an express averment to this effect in their pleadings. The amendment thought it retains the burden on the plaintiff to prove readiness and willingness, but it does away having to specifically make any averment to this end in the pleadings. Similarly, the amendment removes the prohibition on enforcing contracts with arbitration clauses through specific performance, allowing for a more integrated and pragmatic approach to dispute resolution. In contrast to the earlier provision, which allowed compensation either as an alternative or in substitution of specific performance, the amendment enables plaintiffs to claim compensation as an additional relief alongside specific performance. This ensures that plaintiffs are adequately compensated for losses while also obtaining the performance of the contractual obligations. Moreover, the courts are now empowered to appoint experts. This is also a very significant provision that has been added. The courts are now empowered to appoint experts to examine the nature of commercial contracts, determine breaches, and assist in resolving complex issues. These experts may also be examined by the parties subject to the court's permission, which introduce a more informed and effective adjudication process. The 2018 amendment also brings to fore the concept of substituted performance, allowing an aggrieved party to procure the performance of the contract from a third party or its own agency in the event of a breach. The expenses incurred for such substituted performance can be recovered from the defaulting party. Additionally, the amendment includes provisions to allow third parties who have been conferred benefits under a contract to specifically enforce such agreements. This serves as an exception to the traditional doctrine of privity of contract, expanding the scope of enforcement in line with contemporary needs. Recognizing the complexity and public interest involved in large-scale infrastructural projects, particularly those involving government agencies and public-private partnerships, the amendment of 2018 places an embargo on granting injunction that could delay or impede the completion of the infrastructure-based projects. To further streamline this, the 2018 amendment provides an exhaustive list of infrastructure projects covered under the statute, ensuring clarity and uniformity. Special courts are also to be designated by state governments to handle suits related to infrastructure contracts under this Act, enhancing efficiency in resolving disputes in such critical